You are live. So let's do some warm up. We have 4 minutes to do some warm up first. So people come in and say hello. Hello, everybody. Hello, everybody. I'm just going to come here a little bit early as usual. Before we pagi ceramah, we warm up, warm up, warm up. Last time, I screw up the link, because I didn't know how to use StreamYard. Then I had Daniel come and teach me. So now this is the correct link. Now I got it correct. We always learn from our mistakes, right? Now, okay, next, So let's see if anybody is here. Hello, somebody said hello. Hello, Nuru Shahira. Oh my God, you guys are here. So punctual. I love it. So punctual, you all. Today I'm a one-man show. I don't have a person helping me, So you all, before I start, if you have a question that I did not get to read and you really want to know, please do DM me. You can either DM me here on LinkedIn itself or you can go to my IG account. Okay? Hello. The thing is going up very fast. Thank you for coming, everybody. I'm just going to wait for another 3 minutes. 9 o'clock, we start sharp. So now we're just going to warm up and charot about our day. How many of you went to the HR forum today? I had such a lovely time today, Hello from Kuching, Sarawak. Oh, hello, Joyce. Kalau kat kerja punctual tak? Syarul. Sudah pukul 9 malam, you jangan mencarut. Hola. So happy to see me for the first time live, Darren. Oh my God, I'm your idol. Oh my God, I'm humble. Good evening, everybody. Good evening. I look great. Thank you. I did spend some time, to 保重. We girls got me and our makeup. Very important, okay, to 保重. Hello from Mount Kinabalu. Hello, fellow Sabahan. I also from Sabah. I was born and bred in Sandakan, but my family moved to KK. You come here to listen. Okay, today we're gonna. I love your motivation content. Oh, thank you, Nurul Baina. Thank you. Anyways, today, you like my nails? It's $1.99 from Shopee. Anyways, learning from our last sharing session, you guys try to hold your question first. You guys listen to me as much as you can. Then when I pause, then you guys ask question. If I don't get to your questions, then you DM me about it. I lion you one-to-one, okay? Next. I inspire you every day to go to work. As much as I am inspiring you guys, all your kind words are also inspiring me. Hello, Lisa. How am I? I'm very excited. I'm nervous and I'm very excited at the same time to come and give this drama to you all, Because it's a very, very important topic. Managing probationers. It's a very important topic because most of us, when we start work, we are a probationer. Right now. But you got question, you can put in. Don't say tell you to hold. But I can guarantee you, I cannot go through all your questions, because I'm trying to keep this short and simple, because all this LinkedIn ceramah it will get recorded and it will get uploaded. So I'm trying to keep it within 1 hour. Okay? Okay, it's 9 o'clock. Shall we start? Okay, let's start. Okay. Let's go. Welcome, everybody. Okay. So today I'm going to share with you my experience and my knowledge about managing probationers, the trial run. Okay. So how it's going to go? there will be a little different from the format the previous time. Okay, so I will explain to you along the way, like just now what I was explaining, right? You guys try to listen as much can, then we will pause for question. Okay, okay, next. Okay, next one. Okay, just a little bit about me. In case you guys who do not know about me, we're gonna do a little fun fact about me. My first permanent job was actually as a sales executive at a local SME selling audio visual solutions back in year 2003. Nama sales executive lah. Kalau kita nak sound sexy a bit, we call ourselves sales engineer. Then currently 20 years later, I transitioned my career. As of now, I am still the head of a HR, still the head of HR at the leading workforce solutions company in Malaysia. Okay. Right now, I am also an active panel member of the Malaysian Industrial Court appointed by MOHR. I represent employers since 2019. And then something is very exciting that is coming. I will be launching exclusive Dilarang Bodoh merchandise very soon. Some of you follow me on IG and you have seen a preview of my product. So this is all my current projects that is running currently. So that is a little bit background of myself. So today we're going to talk about managing probationers. Before that, I just want you to give a little bit some background first. We're going to do some background. Then, as usual, we will run through some real case laws, and then we will see what we can learn from other people's mistakes. Okay, so here we go. Okay, managing probationers. Now, I'm not sure whether you guys know about this. In the Employment Act 1955 and the Industrial Relations Act 1967, they actually do not have a term called probationer. The term doesn't exist in the act. Okay, but if you refer to the dictionary would say that a probationer refers to employees who are in a trial period, tempo mencuba, or a probationary period for the purpose of assessing their suitability. So it's quite common, it's actually very, very common that when you go to a new job, right, they will give you a probation period. Now, how long is the probation period? Now you have to know there is no act that governs this. So the probationary period can be determined by the company. Typically, it ranges from 3 to 6 months. But I do know some company, especially in the education line, I was told, they're so crazy. The probation period can be up to 1 year. Now, you guys hold that thought first. I will tell you guys why it is not very wise if you put such a long probation period. Okay, now, so how do we manage all this? Okay, so many of the best practices on probationary employment in Malaysia today are actually shaped by case laws. You all are, I am not a lawyer. I just want to tell you, I am not a lawyer. Okay, but I do have a lot of experience studying and managing all these case laws. Okay, so how it all how we do all these things is basically based on all these precedent cases that happened in the past in court. Okay, so today how it's gonna happen is that we're gonna run through these court cases, and then we will see how we can, based on the court cases, how do we come up with the best practices in managing probationers. Okay, now when you go to any court case about all these probationer, right, this is one of the case that is always will be quoted. Okay, Kalia binti Abbas versus Pesaka Capital Corporation back in 1997. This is one of the landmark case that concluded that the rights of a probationer is now held to be similar to the rights of a confirmed employee. So what does this mean? Because in the Industrial Act, right, they have a definition of a workman. which means an employee. They don't separate out whether an employee is a probationer or it's a confirmed employee. They don't separate it. A workman, a workman. An employee is an employee. So whatever that is written in the acts, in the Employment Act or in the Industrial Act, it will be entitled, that probationer will be entitled to the same benefit. I just want to address this question first. Auntie, is this recorded? Yes, it is. And it's going to get posted right after the live, okay? Now, to continue, now one of the very important clause in the Industrial Relations Act 1967, Section 20, it clearly states that no employer may terminate its employees without a proper reason or just cause or excuse. So if you guys need to terminate a probationer, right, it needs to come with just cause or excuse. Now, having said that, a lot of people, one of the most frequently question that people ask me is, as a probationer, am I entitled to annual leave? Am I entitled to sick leave? Am I entitled to EPF and SOCSO? All this will come out. You have to remember again. An employee is an employee. Whatever that is stated in the act, the probationer will be entitled. This will include all statutory contribution. Even as a probationer, you will be entitled to EPF, you'll be entitled to SOCSO, EIS, and your tax will be deducted. Okay? And then on top of that, you will be entitled to sick leave, all these maternity leave, whatever that is stated in the act, your hospitalization leave, you will be entitled. Now, however, when it comes to annual leave, in the law, it states that an employer can hold the annual leave for the first year. A lot of people come and ask, right? How come my boss don't allow me to take leave the first year? Is it legal? Is it legal? It's actually legal. They can hold your annual leave for the first year. The law does state that. However, a lot of company, what they practice is they say that during the probationer period, you are not allowed to take leave. But after you confirm, even though you don't reach the first year, you are allowed to take leave. So what does it mean, right? You actually earn the leave. From day one, you start work, you earn the leave. However, you are not allowed to take it. You guys can understand? Can understand, kan? Okay? So what I'm trying to say in conclusion is, for probationers, you are allowed to earn your leave. However, if your employer said during the first year, you are not allowed to take leave, be it you are a probationer or a confirmed employee, if they want to hold your leave, is actually allowed. Okay. There is some questions already. There is a question. So I take some question first. Do promoted staff need to go through the probationary process? Very good question, this one. Now, when you guys promote a staff, right, most likely this staff is a confirmed employee in the previous position, correct, Asma? So what happened is that there will be a probation period for that particular position you are promoted to, not as a status of your, whether you are probationer or confirmed employee. Because in some companies or Asma, like my company, for example, right, after you are confirmed, you are entitled to extra benefit like optical, dental, all. They will tell you during probationary period, you are not entitled to this benefit that is not mandatory by law. Then after probation, you will be entitled to these benefits. So that status will remain. However, you can put them under probation for that particular position only. Okay, next. How about warning letter within probation period? Is it still valid? Is probation, how come can get warning letter? This is a very good question, Fatin, which I will cover a bit later, right? Okay, now after this, what I'm going to say is there is another case that I want to do. All these are just fundamentals. I want to tell you all these fundamentals first. Okay, in terms of Casey Matthews versus Kumpulan Gayatri Sdn Bhd in 1981, it is also a very common case being quoted at court. Okay, this is a question when you guys would ask me, is there such thing called automatic confirmation? Because in your employment letter, right, they will say that the probation period is 3 months, for example. Then after the 3 months period is over, do I get automatically confirmed? The answer is no. Okay, now in this particular case, what it said that if no action is taken by the employer, either by way of confirmation or by way of termination, the employee continues to be as service as a probationer. Okay, now the key word here you guys have to look at is no action is taken. So what is action? Okay, that is why I always tell you guys, it is highly recommended to confirm an employee. It needs to be done in writing. In this case, what I am recommending, the action is writing. Serve the letter that says that this person is being confirmed. Now, does this mean if the company doesn't give me a confirmation letter, is it I am not a confirmed employee? This is now when it gets complicated. Now this is when it gets complicated. Come this case, Pari Perumal versus Abdul Majid Haji Nazaruddin in a high court back in year 2000. Though the employee was not issued a confirmation letter, okay, Pari Perumal, he was dismissed by the employer by the form of non-confirmation. Okay, but however, during in the case, right, we learned that he did not receive a confirmation letter. However, when Pari applied for leave, his leave was being approved. And in the company, they have a policy that states that if you are a probationer, you are not allowed to take leave. On top of that, as a probationer, he was given a salary increment, and he did not receive any disciplinary letters. Additionally, when he was being terminated as a probationer, they gave him 2 months salary instead of 2 weeks, because the termination notice for a probationer is actually 2 weeks, not 2 months. But he was given a 2 months salary. So you see, in this particular case, the conduct of the company showed that they treated the employee as a confirmed employee. So Pari Perumal won the case as a confirmed employee. This is very important. I want to repeat again. Okay, in Casey Matthews, it says that if no action is taken by way of confirmation or termination, you will continue as a probationer. However, if it's not in writing, you say they did not say what is the action. But if you do all these funny things, you approve their leave lah, you give increment lah, you are treating them like a confirmed employee, right? Therefore, when it goes to court, it will be argued as a confirmed employee. Okay, so with that, I'm just going to pause here first to take some questions. I see got many questions going on. I will just going to pick some questions to talk about. Okay, now this is a good question. James asked, does the confirmation need acceptance from the employee? No. The company doesn't need your acceptance to accept as an employee. However, I understand you people. Because as a confirmed employee, the notice period is longer, right? So you guys refuse to get confirmed because when you tender, you want to tender with a shorter notice, right or not? So what you guys can do, if you guys membangkang to be a confirmed employee, you actually have to write back to the company to membangkang the confirmation. And it's also up to the company if they want to accept you to membangkang. It has happened in the past before, but you guys need to be very careful. Nobody will all do all these funny things. When you guys do all these funny things, there will be consequences. You guys remember that, okay? Okay, next question. What is appropriate time to tell an employee that not confirm or extend probation? This is a very good question. I don't know how to read yet. Nianam bigay. In all your offer letter, right, there is a termination notice. So in case you do not want to confirm the employee, you want to terminate, you have to follow the termination notice. This one, I will cover it a little bit later also. Okay. Now, if the staff tender after confirmation letter been issued without the acceptance or acknowledgement of the employee, which service notice shall follow? Okay, again, like I mentioned earlier, James, right? You don't need to have the employee accept the confirmation. In this particular case, there will be such thing called automatic confirmation. Once the employee serve you the letter that you're confirmed and they have proof that you received the letter, you will be deemed as a confirmed employee. Okay, so now we're just going to look at some cases. Okay, you guys hold your question first. We go through the cases first and we're going to take the questions again. All right, okay, so let's look at this particular case. Now, most of the time, employer will terminate somebody because of unsatisfactory performance. Right now, okay? So in this case, Wong Chun Moy versus Practimas Sanjan Berhad, okay, which happened in the year 2013, the case. Okay, so we go through some case facts first. The employee was employed on 16 June 2004 as a sales manager with a 3 months probation period and was dismissed on 26 August 2004. You guys see, so long the case. So you see, she was just employed for 2.5 months, then she was being terminated already. Okay, now she said she was terminated without just cause or excuse. However, the company listed down all her faults. The company said she was a probationer. 1. She failed to achieve the promised sales target that she mentioned during the interview. 2. She missed her daily sales meeting because she was always late in the morning. 3. On top of that, she pinched customer from other sales rep. With all this misconduct, plus the fact she is a probationer, therefore we have the right to terminate her by the form of non-confirmation. Now, what are the findings from this particular case? It was found out, number 1, her sales target was not spelled out clearly in any documentation. You see, the boss said she did not hit her sales target. But what is her sales target? It was all just verbal. There was no document about it. So when they showed the court she was not hitting the sales target, she defended, that is not my sales target. Number 1. Number 2, throughout that 2.5 months, with all the things that they say, she was late, then she pinched the customer, right? The company did not issue any warning letter to the employee regarding her unsatisfactory performance. Okay, then on top of that, when they served her the termination letter, there was no reason that was stated for the termination. Okay, so finally, the outcome of this case, the court found that the company failed to discharge its burden of proof, and the dismissal was without just cause or excuse. So she won the case, and the company was ordered to pay her 10 months of her last paid wages. You see, she only worked 2.5 months there, but she got 10 months compensation. So what did we learn from this case? So what I learned from the case, number one, when you guys hired somebody new, it is very important you guys do what I call goal setting. Your goal setting, when you guys need to do appraisal, and then I know a lot of you guys only discuss the goals out when you guys do the appraisal. It is very important during the first 2 weeks itself when an employee start work, you guys set smart goals. Get the expectations cleared, have it documented. If you guys want to give a sales target, make sure it's written clearly. You are supposed to do 200,000 per month. Has to be very specific, smart goals. It has to be very clear. Okay, and then if you find there is any misconduct, just now somebody asked, right? Can we serve warning letter? You can. Regardless whether you are a confirmed employee or you are a probationer, a misconduct is a misconduct. If you think the employee committed a misconduct, then you take disciplinary action accordingly. Like for example, in her case, they say she is always late, right? Then remember the time I was talking about absenteeism? If they are always late, then you give a show cause letter followed by a warning letter if you feel their explanation is not satisfactory. Okay, you guys can take disciplinary action accordingly. That is when the warning letter will come out. Okay, then the next thing I want to tell you, there are previously law cases that say that for a probationer, they are in a trial period, correct? You cannot terminate a probationer based on performance issues alone. You cannot, because the argument is you are giving this person 3 months to try, right? You hired me, you give me 3 months period for me to prove you that I perform. Until my 3 months is up, you cannot terminate me. You cannot say I don't perform because I have time. That is why I said earlier, for some of the company, you want to put a probationary for 1 year. Can you imagine somebody who is not performing for 9 months? And then you still cannot terminate because they're not performing. It's very high risk. I will not recommend you put 9 months. 6 months is probably the maximum that I can recommend. Okay, so with that, I'm just going to pause first to take some question. Okay, I saw this question. Hi, does anyone know what EPF and SOCSO is under what benefit? Oh, you think Hashwana, is it about probationer? A probationer will be entitled to EPF and SOCSO. It is. Okay, next question. There is waiting period for companies to send the confirmation letter. I was told maximum 3 months waiting period after finished probation. If not receive any response from HR, consider as extended or termination. No. Hakim, Iman Hakim. No. Now, however, there are some companies, right? What they write in the employment employment contract, they do write the fact that you will be automatically confirmed. Sometimes they write that. They write that if 3 months, if there is no action by the company, you are automatically confirmed. Now, if they write that in your employment contract, then you will be automatically confirmed. So how you guys word your employment contract is also very important. But the rule of the thumb is, remember, Section 20 said that you cannot terminate an employee without just cause or excuse. So if after your probation period is finished, they cannot simply terminate you. Cannot. Okay? Okay. Next one. I'm going to just talk about this case first. Okay. Indra Devi versus Everhome Furnitures. Okay. Now, this one, the case facts. The employee was employed as a HR junior executive on 11 February 2009 with a probation period of 3 months. Okay, now the company had verbally spoken to the employee about her mistakes and advised her to rectify her mistakes, and yet she failed to improve her performance. Actually, what she did, she was hired to do some payrolling, and then she did some payroll mistakes. The company terminated the employee on 15 January 2010. Now, this one, she is in employment for 11 months before she was terminated as a probationer. Okay, that she says that her performance did not meet management satisfaction. So you see, in this case, her probationary period was 3 months, but she was never confirmed and she continued to work for 11 months, right? Okay, now what are the findings of this case? Again, the company did not produce any documentary evidence, such as warning letters, to the employee about her alleged below standard performance. Okay, so when you guys do not give them show cause letters or warning letters, how it's being viewed in court is that the mistakes were viewed as minor and could be easily rectified if the employer had provided proper guidance and training. Okay, the court stated that dismissal solely based on these small mistakes without any written warning was not justified. Okay, on top of that, there was also no appraisal done on the employee. So the outcome of this particular case is the court ruled that the dismissal was without just cause or excuse. So Indra Devi was awarded a compensation equals to 5 months of her last drawn salary. So in this particular case, what did I learn? Okay, so when I study this case, number one, again, if the mistakes that they make, you do not take disciplinary action. So to the court is small mistakes, and termination is a very heavy punishment. You don't punish someone heavily based on small mistakes. If you think it's a major misconduct that warrants termination, then you will take disciplinary action accordingly. Okay, so this is what happened. Now, another thing that I've learned is they brought up the fact that there was no appraisal done on the employee. Very important word, appraisals. Because if you want to terminate a probationer, right, you can. But you need to give time for the probationer to improve. You have to provide them training. You see, the court also said that you guys need to provide them proper guidance and training. And you, of course, in order for them to improve, they also need to know what to be improved, correct or not? So during the appraisal, you guys need to do it so the employee would need to know what they need to improve. So here, some of the keywords that we have learned is appraisal, okay? Proper guidance and training, okay? So with that, this is how I come up with the best practices of managing probationer. Learning from all the cases that we talked about just now, from Kalia Abbas all the way to Indra Devi. So when you manage a probationer, this is how you manage a probationer properly. Upon commencement of employment, when they start work, they should be provided their duties and responsibilities. Okay? As a newbie in the company, it's the employer's jobs to provide training and counseling and guidance to carry out their task. This is when I said that during the first 2 weeks, you guys need to sit down with the employee and do a goal setting. You need to do goal setting. What is considered as performing, what is not considered as not performing. Okay, and then throughout the probationary period, the supervisor should regularly monitor the probationer's performance. So that is number one. Then during the midpoint of their probationary period. So like for example, right, if the probationary period is 6 months, so on the third month itself, you need to do a midpoint appraisal. So if it's 3 months, then 1.5 months, you guys need to do a midpoint appraisal. You need to identify what are the areas of improvement, and so that they can have the opportunity to address any deficiencies. Again, you guys need to give them ample time to improve. You tell them what they are not performing on, and you give them ample training and time to improve. So the best time to do this is during the midpoint of the probation. Okay, they should be provided all this advice, counseling to enhance their performance. This is the one. This particular step number 2 is the one that you guys always miss. Okay. Then next, if the employee is carrying out their duties and responsibilities satisfactorily, so during the appraisal, right, you feel they are doing well. So what you're going to do, you're just going to continue to monitor them until the end of the probationary period, followed by confirmation in writing. Okay. Now, if the company feels that this is a super performer, you guys want to confirm them early to promote employee retention, also can. Now, what happens if you're not happy with that? Now, at the end of the probationary period, if the employee is found unsuitable, then you may terminate their employment by serving the termination notice. You still need to serve the termination notice. So just now somebody asked, right, when is the best time to tell them about this? So it depends how you want to do it. Okay, so if you want it to be like, I give an example lah. So let's say the probationary period is 6 months, and in your employment contract is written for a probationer, the notice period is 2 weeks, for example. So 2 weeks before the probationary ends, you guys already need to serve the termination notice, termination letter, and then you can run the 2 weeks. But what I will highly recommend, right, you guys extend the probation period. That is what I highly recommend. Now, how long do you want to extend the probation period is up to you guys, but it needs to be reasonable. Okay, it depending how you think how much time this person need to be more. Then comes another question people will ask: how many times can you extend a probationer? Can you extend it like 3-4 times? Actually, you can, as long as you feel the employee is not meeting your expectations. You want to extend it and give them more time to improve, is okay. Okay, there are a lot of times I see even my head of departments, right? They extend this one 3 months. 3 months later, not happy. They still want to give a chance. So they extend again another 3 months. I know some employees they extend the probation up to 2 years also got. Then then it begs the question: if this person is not performing for 2 years, why is this person still here, right or not? What is wrong? What is wrong with the company? What is wrong with the employee? That is what I always say. Okay? Anyways, coming back here. I highly recommend you guys do the last hurrah. Okay? Just help out them one more time. Extend. Okay? And during the extension of your probation, you guys can write it very clearly. We are going to extend you 1 more month. Shall you not improve according to the company expectation, we will terminate your employment accordingly. Okay? Now, a lot of you here are HR. I want to tell you in HR, your paperwork kena cantik. That's how you be a good HR. So when you guys serve the extension of the probation period, you guys need to be very clear with the consequences. So it will not come in as a surprise to the employee. Now, as an employer, we already did all the best we can. We already provided you training. We told you already what is not right. We gave you time to improve. You asked for training, we gave it to you. And yet you still do not improve. Hence, you also need to be fair to the employer. I will have the right to terminate your employment by means of non-confirmation. Okay, so with that, I'm just going to pause here. I see there is so many questions. Okay, so I'm just going to just go out and start looking for question. Okay, so we're going to start with this one. Based on my understanding, even any employee under probation, to be at the safe side, if we want to terminate him or her, we should still go through PIP process, such as warning letter, show cause letter, set goals, and shouldn't just give 24 hours notice. You are not wrong, LinkedIn user, because I think you're setting hide your username. Okay. You are right. You shouldn't give 24 hours. Actually, if you guys want to terminate a probationer, like what I said, right, you still need to serve the notice period as per the employment contract. You give them a termination letter, you still need to serve them the notice accordingly. Okay. Now, a lot of people especially some of the hiring managers come and tell me, it's already written in the contract, termination notice, we can terminate either party by serving notice. No. Remember, again, I want to repeat this again. Section 20 said you cannot terminate an employee, regardless they're confirmed employee or probationer, without just cause or excuse. It needs to come with a just cause or excuse. And unsatisfactory performance is not considered as a major misconduct for a probationer. It's not. Now, why I say it's not wrong? Because of this word PIP. To terminate a probationer, right? PIP is not necessary. It's not. So the proper document to use is actually the appraisal document itself. You don't have to go to the length of a PIP. You can, because you have to understand for a probationer, right? I don't know how to say this. Not to say they are not expected to perform. For a newbie who is not performing, it is not uncommon. You get what I mean? Because they are new to the company, right? You cannot expect somebody come in a company and straight away performing like a superstar. You cannot. So when you give them a performance improvement plan, it indicates that you give them an expectation. You come in, you straight away have to perform, which is not the case. So the more appropriate document to use is the appraisal document, okay, to list down what they are not performing on. Okay, next question. Let's say an employee is given a new position with an increment. After the probation, the employee is not confirmed. Employee goes back to his previous position and the increment is no longer available. That means back to the previous salary. According to the Employment Act, how do we treat this? Do we provide the non-confirmation letter, reverse salary, and non-confirmation reason? Deepa, you wait, I have to drink first and think about your question so panjang. I have to dissect your question part by part way. Let's say an employee is given a new position with an increment. Okay. After the probation, the employee not confirmed for that new position. So employee goes back to the old position. The increment is no longer available, which means they reverse your salary, right? According to the EA, how do we treat this? Now, the EA doesn't state about this. This one also, again, need to refer to case law. I cannot think about case law out of my head now, but I can share you some of my knowledge. Your particular case, you probably need to DM me. But I will tell you how you guys can do this properly. If you guys want to give somebody a new position with an increment, what you guys can implement, right? You give them an acting role first. You're not sure whether this people can perform or not. You want to put them on a probationary period. what I will recommend you guys do, right? You give them an acting allowance instead, or a responsibility allowance. So if you guys want to reverse this, you can take away the acting allowance. You get what I mean? You don't give them straight away the increment, because to once it goes into your salary, this one is considered as a demotion, Deepa. If you go back to the previous position, which is a lower position, right, it's considered as a demotion. A demotion can come with a salary reduction. It can. But that one is a different charama altogether. There is a due process how you demote someone and cut somebody's salary accordingly. There is a process to go about it. So to answer you, it's can, provided your company follow due process. Okay, next. Can we issue warning letter 2 months after the mistake happened? Well, this one is a very generic question. It's not recommended. However, have to see why you guys issue it 2 months later. Is it because you guys just discover it 2 months later? A lot of times when it comes to all this misconduct, it's not surprising. When the auditor go audit, only then they found out there's a misconduct. Correct or not? So you actually can, but depending what kind of mistake it is, it cannot be a mistake like you are late for work 2 months ago. Then cannot. It cannot be something like you are late 2 months ago, but it can be if it's a very serious mistake and you guys found out recently, only now you take action, then that one is can. Okay, next. If probation is extended and coincidentally company goals have changed, can the probationer goals KPI change fairly as well? This is a very good question, which means they say you're not performing, then they extended you. Then after that, the company changed direction, right? And they also change your KPI goal as well. Actually, it can. It can, because you guys also have to understand nowadays the business is very fluid, it's evolving very fast, especially after this pandemic. Overnight KPIs can just change like that, right? But however, it needs to be reasonable, Jinsen. Whatever they change your goals and your KPI, it needs to be reasonable. It cannot be so far away that it's unattainable. It cannot be. Again, SMART goals. A for attainable. It needs to be attainable. Okay, next. Probationer MIA and did not submit resignation letter. Can company hold salary? No, cannot. But, Adeline, in the employment contract, right, there will be a termination notice. Correct or not? And then it depends how long is a termination notice. If they MIA, means they self-terminate the contract, they did not serve the notice. So you guys still need to pay salary. You guys need to calculate the salary. You minus out their notice in lieu that they did not serve. So if it's not enough, if the value is negative, then on top of you can hold the salary, you can send them a demand letter to demand back the negative. Now, however, if it's positive, there is still balance, right? Then you need to pay them accordingly by the 7th day of the following month. Okay, you cannot hold salary. This is also a lot of people ask me, what if the employee don't do the handover? Can we hold the salary? All is cannot, okay? You all jangan bagi ajaran sesat, is cannot. Okay, next. Is there any minimum or maximum notice period for probationer? No, there is no, but it needs to be reasonable. So the common one, the most common one is between 2 weeks to 4 weeks, 2 weeks to 1 month. That is the most common one. How about zero tolerance policy? which very severe, example like harassment or insulting other, can lead to immediate termination or still need to go through notice period. Okay, Eric Chat, no. This one, yes, can. If it's a major misconduct. So in the Employment Act, it also does say that you can terminate someone without serving notice period. If you can prove it's a major misconduct, you can. Like all this zero tolerance policy, especially sexual harassment. Sexual harassment is a major misconduct. You guys don't play a fool around it. That one can get you terminated immediately. Okay, next. Hi, do I need to give letter if I want to extend staff probation after her probation original period end? Firstly, it's recommended. In all good HR practices, it's recommended you guys have everything in black and white. Okay, in case something happen, the case goes to court or get reported to JTK, they will ask you for evidence. And evidence always needs to be in writing. So we highly recommend you. However, the earlier, like the case that I share with you, right? If you guys don't give them a confirmation letter and you continue to treat them as a probationer, then they will continue to service as a probationer. Okay, next one. How to terminate a non-performing probationer who doesn't have misconduct? Eunice, like what I said, you have to do a midpoint appraisal. Okay, again, I repeat again, want to terminate probationer, you all Number one, do a midpoint appraisal. Do a midpoint appraisal. That is the most important one because you guys need to tell them why they do not meet your expectation and what they need to improve on. You need to give them ample time to improve, and you need to give them training if they ask for the training to improve. Now, after you already tell them why they are not performing, you already give them time to improve, you also give them guidance to improve, and yet they still cannot, then you can terminate the probationer accordingly. Okay, next. What about terminate probationer due to unsatisfactory performance and medical reason? She unable to do her job due to medical reason. Very good question, Adlinor. Now. This one, they are entitled to sick leave. They are entitled to sick leave, especially pregnant mothers. Pregnant mothers, now the law does state that you cannot terminate a pregnant mother simply. Cannot, So this one, right, again, you have to see what is the medical reason. Again, do a midpoint appraisal. Okay, you guys sick or not sick or whatever, you guys still need to do your job. Again, the same process. The process is all the same. When it comes to based on performance, right? The performance is the same. Appraisal. Okay, next. When you start a new job and after 2 weeks, there you still have not get your offer letter. Although you have talked to HR department on it, how to politely ask for it, or can that staff just leave the company without giving any notice? Emily, why you start job without an offer letter in the first place? Cannot. Now, in the absence of an offer letter, the Employment Act now also have a clause that differentiate you whether you are contract of service or contract for service. That rule is originally written for all these cases in the event there is no offer letter. So if they can prove that you are a contract of service staff, then the Employment Act will override as the offer letter. That is the rule of that is the guide to my knowledge. So in your case, can you give notice without notice? Actually, there is no contract. I will not recommend it, Emily. What I will recommend you guys talk to your boss about it and come to a mutual agreement to leave. Don't burn bridges. Okay, next. If the employee being bonded a year by the company, but what if the company terminate during probation period due to underperform? Upon signing employee contract, you'll need to compensate the bond with salary. Trista, when it comes to bond, you have to see how they word the bond accordingly. Because all this you already agree and sign that you will pay the bond. When it comes to bond, if you agree to pay the bond, then you will be penalized for the bond. So what I will recommend, right, you guys can write in. You write in to appeal to waive the bond because it's not like you don't want to serve the company, ma. You want to terminate me, ma. So you cannot penalize me for being not performing, then you don't let me to finish the contract. So in your particular case, I would say that why don't you write in and ask to waive the bond instead. That is what I will recommend you to do lah. Okay, next. A lady worker is having the 98 days maternity leave and tender during the last 30 days. Can they just leave the company like that? This is a very good question, huh? Although it's not related to probation. It can. Even when you're on hospitalization leave, you can tender your letter. I always say, when you tender notice, you tak payah tilik tarik. Any day is a good day to tender. So yes, James. So in this particular case, her maternity leave and her notice period will jalan serentak. Okay? But whoever that lady worker is, I will advise you, you join the company nicely, you leave the company nicely. At least come back to do your handover. Do not burn bridges. I understand all these mothers, they want to take care of baby, they don't want to come back to work anymore. It's okay, but at least come back to do your handover. But James, if they mati tak boleh balik, they tak nak balikan, is also can. Okay, next. If an employee was hired for one position in the offer letter and then after the probation period ended, the confirmation letter stated different position. Is this legal? Which position is correct? You know what, Shafika? Very hard for me to answer you this because what they are doing is redesignation. They redesignate you, right? Again, they can do it legally, but there is also a process to go about it. For this one, you need to clarify with your HR. By right, whatever is written in your employment contract, you join the company because of this. That is why you join the company. If you guys change anything, it will require the employee to agree. If you guys want to change anything in the original employment contract, right, both parties need to agree. So in this particular case, Shafika, when they give you on the different position, right, they will require your consent to agree about it. Okay, next. Let's say if this person not meet PIP goals, does PIP record from previous company will affect one for the next job in a new company? Well, it depends if the new company is conducting a reference check. When you guys move from one company to another, you see in a company, a department already don't talk to another department, let alone one company talk to another company. So as long as they don't find out, then it's fine. But Ahmad Ashraf, if they conduct a reference check, and the person asks, can I check, is Ahmad been through PIP before? Then they say, yes, he went through PIP. They found, then obviously it will affect you lah. So So for me, as long as the reference check is not done, it will not affect your next job. Okay, next. Under probation, in the contract, your position is HR, but then the company change your position verbally to do account part. Is it legal? This one I don't understand. They expanded your role, is it? Again, there are processes to go about it lah. Anything they change to your original contract will require your consent, Shafiq. There are ways to go about it to do it. There are ways to go about it to do it to make it legal. Your HR just need to be pandai how to manage this. Okay? Next question. Itu macam jawab macam tak jawab kan I. Sebab your information tak cukup. All your big question kan, I will recommend you DM me because I have a lot of questions in written to ask why is it happening like that. Okay, Amza, is the HR can suggest the employee to resign instead of giving termination during probation? No. Employers out there, you never can force resignation. It's a big no resignation can ever be forced. Cannot. Okay, next. Okay, I'm just going to finish it because it's already 10 o'clock. You guys hold your question. Okay, now I want to give some last but not least advice. Managing probationer requires a lot of patience. It requires clear expectations, regular monitoring, and constructive feedback. In the beginning, when you hire, make sure you make the expectations clear. Then you do midpoint appraisal and give the constructive feedback, and you do regular monitoring. That is how you manage probationer. I want to tell you, to hire an employee nowadays is so difficult. You remember the time that you invest the time to interview and select this employee. It already taking you so much time. So you invest in their success. Do all you can to help the employee to be confirmed. Invest in their success to set the stage for long-term growth. Now, for employees, after your employee did all that to you, and yet you turn out to be a disappointment, then you shall be terminated. Because as much as we want to be fair to the employee, we also need to be fair to the employer. And you guys always need to remember the employee always come first. Okay, next. Okay, guys, I want to end the podcast tonight. Okay, thank you so much for coming today. Thank you so much for coming today. If you guys have any burning question, please do DM me. You send me a direct message. I lion you guys one-to-one. I always clear my messages every day. If you see me don't reply your message, kan, you know, sometimes like WhatsApp, we tak baca your thing, the thing turn blue, but actually we never read. It happens to me sometimes. If you see me don't answer you, you just send me another, hello auntie, can you please answer me? You just send me again to remind me to answer you. So with that, I'm going to thank you all for coming today. I wish you all the best, whoever you are. If you are under probation, I wish you all the best to get confirmed. Okay? With that, I will bid my farewell, everybody. Bye!